Good afternoon. Calling our next case, in re Parole of Richard Allen McBrayer. Justice Viviano is recusing himself from this case and will not be participating in the oral argument. This is a mini oral argument on the application. We have 15 minutes set aside we've got 20 minutes for the defendant and the parole board, and my understanding is that it's 10 minutes per side. If you're going to reserve time, just please keep that in mind and keep track of the division of time. You may also use a 2-minute free fire zone, or you may waive that.
Thank you, Your Honor. May it please the court, Jacqueline Ufrey, Maya Menlo from the State Appellate Defender Office on behalf of Richard McBrayer. Also at council table are Steve Langschwanger and Chris Allen from the Attorney General's office. As Your Honor stated, we each have 10 minutes. We have agreed that we will reserve the remainder of whatever time for my rebuttal. I will keep my own time, Your Honor.
Thank you.
Your Honor, the rule we ask this court to declare is that when the parole board follows the guidelines, it only abuses its discretion if the only reasonable outcome is to deviate from the guidelines. The board did not abuse its discretion here. There is ample support in the record that comes in the high probability guideline score that is a stellar +11, that comes in the nearly 30 years that Mr. McBrayer has been incarcerated with a single ticket. He has completed sex offender therapy both in prison and out in the community when he was in the community on a prior parole for 2 years and did not violate. There's also support in the record in multiple evidence-based risk assessment instruments that find Mr. McBrayer low risk. Where this court can provide guidance is in the abuse of discretion deferential standard of review that the Circuit Court and Court of Appeals failed to apply here. The Circuit Court and Court of Appeals failed to look first for whether there was support for the agency decision in the record and consider the nature of that support, whether it was cherry-picked. It was not here. There's ample support in the record. For that reason, this court should reverse and reinstate parole. I welcome questions at any time. I have suggested that this court can provide guidance in the abuse of discretion deferential standard of review because this is an administrative agency. This is a separate branch of government that the courts are reviewing. And in several opinions that address that abuse of discretion standard, the Purdy case cited in my brief, the In re Rovis case cited in the Attorney General's brief, the courts describe that the role of the courts in these reviews is judicial restraint. It is deference, not de novo review. The reviewing courts are not supposed to engage in their own fact-finding, and that is what the reviewing courts did here with regard to substantial and compelling reasons. We have longstanding jurisprudence in our state in regards to the sentencing guidelines about what substantial and compelling reasons mean. In the Babcock case, we know that they mean things that keenly or irresistibly grab the attention and are of considerable worth. Both of those factors are important in deciding substantial and compelling reasons. The reasons provided here by the reviewing courts do not meet that standard.
Would you say that the reasons provided in the prior 3 reversals did meet that standard?
No, Your Honor. The reasons provided do not meet that standard. They are problematic for the reasons articulated in my brief, but most importantly, they're problematic for this analysis because this analysis is a separate decision. There is not collateral estoppel or res judicata that applies here. The reviewing courts are reviewing the 2020 decision of the parole board.
I understand that, but I'm getting at your point of what is substantial and compelling reasons, and I'm trying to understand what that could be. So if, I know we're not looking at those prior decisions specifically. That's not what's being appealed here. But would you say that substantial and compelling reasons were raised in those prior instances?
So in the, what we know the standard is that substantial and compelling reasons is the Babcock standard. We also know that in the jurisprudence about substantial and compelling reasons, it has to be objective reasons. This court addressed that in a parole appeal in Osentowski. Those reasons in the prior appellate decisions, Mr. McBrayer's position is they do not meet that standard. The realistic parole plan, the nature of the crime, those have diminished. Certainly.
Okay, so what about his prior confession a few years ago? Again, but I think before, trying to keep track of them, but I think before the third review, to still being attracted to minors, and also lying about his previous location plans to Louisiana.
I believe if I heard Your Honor correctly, I think Your Honor used the word lying, and I don't believe that's appropriate on the facts of this record. Because what occurred with that prior parole plan to Louisiana is that there was an address provided, the parole board went to that address, and it was the wrong address. And the records in the parole board file that have been provided to this court substantiate that. As to Your Honor's question about the prior, the statements in the 2018, the admitted attraction to children. I use the date 2018 because that refers to a sex offender evaluation, and that's where those statements are contained. In that evaluation, the evaluator is interviewing Mr. McBrayer, and the first sentence of the paragraph to which Your Honor refers does say Mr. McBrayer admits attraction, and then it goes on to say that Mr. McBrayer has attended therapy and that he has not committed acts of masturbation to that age group since 2015. So there is a past tense statement in that 2018 evaluation. And by the 2020 evaluation, Mr. McBrayer is talking about how he has been on parole, how his relapse prevention plan has been tested in the community, and he says that that attraction is no longer there. And the reviewer incorporated Mr. McBrayer's statements, incorporated the prior sex offender evaluation.
Okay, yeah, thank you for, for kind of going through kind of the history here. I guess what I'm asking is, and not just what we've given as the definition of substantial and compelling reasons, can you give me an example here where there would be substantial and compelling reasons? Or is it just an automatic, if your score is high enough, the statute says that it's automatic, and there's really nothing there's no substantial and compelling reasons that could call that into question.
So our statute certainly isn't written to say there's no substantial and compelling reasons. Our statute says that the guidelines cabin the parole board's active discretion. They have that exclusive discretion, but it is cabined by the statutes that the legislature has designed. And they have provided that high probability and low probability scores can be deviated from when substantial and compelling reasons exist. An example of a substantial and compelling reason could be new bad information after the evaluations have been entered into, after the guidelines have been scored. This is a process that takes several weeks for the parole board to score these things, to interview someone, to review someone, and there can be new facts that arise in that time period. New bad information could be a substantial and compelling reason.
And would that have to be information that occurred after the parole board hearing where the decision was made?
I'm saying that is one example of what a substantial and compelling reason could be. But it could be new
information that they weren't aware of from prior to the hearing.
Correct.
It could have happened, in the year prior to, and they just weren't aware of it at the hearing.
I'm saying things that happen subsequent to the hearing. So there is a time period between the hearing and between release. So there can be things that occur that could arise to the level of substantial and compelling.
What if something happened before the hearing that the parole board wasn't aware of? That they were made aware of after the hearing.
So if the parole board becomes aware of new bad information, I am saying that that could be a substantial and compelling reason.
Even if that information came from conduct that took place before the hearing?
If it's new to the parole board,
Okay.
yes,
Okay,
yes.
thank you.
Did I understand your argument to be that if there is a high probability of parole and the board grants parole, it cannot be an abuse of discretion?
My argument is that the board only abuses its discretion if the only reasonable outcome is to deviate. And I think that comes from longstanding jurisprudence about abuse of discretion. That abuse of discretion incorporates.
All right, is there a difference between what you just articulated and this standard? First question, is there substantial and compelling reasons to deviate from the guidelines? If yes, then the question becomes, was the board's decision not to depart from those guidelines reasonable and principled?
No, Your Honor, I think the analysis is the reverse. And I think that that comes from our abuse of discretion standards, the fact that this is deferential review of an agency decision. So the appropriate role of the reviewing court is to look first for whether there is support for the board's decision. And also, as has been put forth by the Attorney General, it is not automatic that if substantial and compelling reasons exist, that the board must depart from the guidelines. The statute uses the word may, which allows for the outcome that substantial and compelling reasons can exist but not require deviation. I think that also comports with how Babcock has defined substantial and compelling reasons, that they must both keenly or irresistibly grab the attention and be of considerable worth. That means that something can grab the attention but may not be of considerable worth. And I think here in this decision, where there is multiple objective record evidence of Mr. McBrayer's rehabilitation, the reasons put forth by the board support their decision, demonstrate rehabilitation, demonstrate a meaningful explanation for the board's decision.
So the board chooses not to deviate. Is it reasonable? You're saying yes.
Yes.
So I don't see the distinction that you're making from the standard I proposed.
Your Honor, the distinction I was attempting to make was in the order of the analysis. The rule that I am asking for is that the board only abuses its discretion if the only reasonable outcome is deviation.
Okay.
Counsel, I just wanted to sort of echoing Justice Clement's questions. What about the original plan where your client was going to return to the same county? Would that be substantial and compelling? Is that something that the Court of Appeals could consider?
So the plan to return to the same county was part of a prior appeal.
Right, part of the original. I understand that then got modified. I understand that. But I'm just sort of, again, we're trying to grappling with this, what is substantial and compelling? And is that enough?
No, Your Honor, it's not enough for multiple reasons. First and foremost, the board is deciding whether someone is worthy of release, because the board's role is to determine whether or not someone has rehabilitated. Where they return to is just one factor within a multi-factor analysis. And here, what the board has done is propose placement in Oakland County, which is not the same county where the victim lives. It's not the same county that was the placement before. And in fact, even when Mr. McBrayer was paroled to the same county where his victim lives, he lived there for 2 years without violation. So the board has to take a look at all the facts and circumstances to determine if there's reasonable assurance that somebody can be safely returned to society. And I think it's also important to consider in that analysis that this is a conditional return. That's something this court has recognized back in 1926 in Edinger, that the purpose is rehabilitation, it's conditional release to society with the threat that someone may be returned to prison if they do not follow conditions and do not demonstrate the rehabilitation that the board found. So within that analysis, placement is but one factor, and it is not a factor of considerable worth when there's so much objective evidence here of Mr. McBrayer's rehabilitation. Also, what the board has to consider is where placement will be successful. And
We only have 5 minutes, a
I
little
will
over 5
reserve,
minutes
Your Honor.
left. Yeah.
Thank you
so-
kindly.
Your Honors, Chris Allen, Assistant Solicitor General on behalf of the Parole Board. I wanted to really focus on two general themes. I see my time's a little limited here, so I'll do my best. But generally, two overarching points. The Circuit Court and the Court of Appeals substituted their judgment here for that of the Parole Board. And I think the Court of Appeals also, in doing so, used an erroneous legal analysis. So the legislature has entrusted the Parole Board here to make its decisions based on whether there's reasonable assurances that a prisoner will not recidivate. And the legislature has a lot of oversight here. While we're arguing about having substantial deference to the board, the legislature has a measure of deference as well. Excuse me, a measure of oversight and direction. And so the legislature tells the parole board when to consider parole, generally what to consider, what not to consider. It required the creation and implementation of the guidelines and the ultimate statutory charge, which is not about punishment or retribution. It's about whether the individual can be paroled consistent with public safety. And
Talk to me about what you think the legislature's intent was for the court's role in this, because the court doesn't have a role if parole is denied, correct?
correct.
So the legislature made that decision. Courts are not going to be involved in that. We're not going to have, prisoners that have been denied parole an opportunity to appeal that. But they did leave it open for prisoners that are granted parole.
Correct.
So explain to me what you think that role is, and help us understand what substantial and compelling is and what role the court has in that
Sure.
analysis.
Sure. So first, I would endorse Ms. Ouvry's characterization of the abuse of discretion standard, because the nature of the decision is an either-or. It's parole or not parole. And it can only be outside the principled range of outcomes if deviation is the only principled outcome. So I think that kind of sets the tone for the level of deference. But as far as substantial and compelling reasons go, I think there's two sources that this court can look to. Number one is Babcock in the law on sentencing, substantial and compelling reasons. I hesitate to suggest the court adopt that in whole because, again, the purpose of the parole board and the purpose of a sentencing court are very different. But I think the general rubric about keenly or irresistibly grab the court's attention exists in only exceptional cases. That holds true. And those reasons should be directed toward the public safety purpose that ultimately the parole board is statutorily required to guide its decision. The other area, I think, is in the statutes. In 2018, the legislature revised what substantial and compelling, well, expanded on, in some ways, what substantial and compelling reasons means. Now it's substantial and compelling objective reasons. And those don't specifically apply to this case. I'm not arguing that because the crime the cutoff is whether the crime was committed after 2018. So the legislature has really cabined what constitutes a substantial and compelling reason to, I believe it's 11 things. It's limited. It's not substantial and compelling reasons may include. It's substantial and compelling reasons are limited to this universe. And one of those, Your Honor, you're looking kind of for an example, a threat, a realistic threat to someone on the outside. They could have this entire record, but if the individual makes a threat to someone, that's a substantial and compelling reason. Now, the board would still have to evaluate the totality of the evidence, but I think that would be a pretty strong signal that looking at everything, including the threat, including the great record, would be a problem. We don't have anything like that here. There's a few other examples.
I know that this was in one of the prior parole decisions, reversals. I think it was the third time. And I had asked counsel if this would have been substantial and compelling. defendant's confession a few years ago to still being attracted to minors. You know, and whether that was in 2015,
Sure.
2018, you know, the parole board has, at this point, has now, it's been 4 times that they've paroled. So at some point, that information was provided to the parole board, and they still moved forward with parole based on the score.
Sure.
So is that something that could be reviewed by the court as substantial and compelling?
I think conceivably it could be, but I want to put that in the proper context, Your Honor. That finding of deviant sexual interest, I think, is the trigger. That came about because of a psychological evaluation that's done every time a sex offender is up for parole. I think there's 4 of them in the record. And it's part of essentially a questionnaire that's part of the stable risk assessment. That's done every time. He's interviewed by a psychologist, and this is separate from the parole guideline scoring, but there's a separate risk assessment score. And that fact that you're talking about, Your Honor, was part of that risk assessment. I apologize, I see my time.
Yeah, please continue.
Part of that risk assessment, I believe it's 13 variables, that was one, and that was scored as an area of significant concern or some concern. But that's one fact of several that ultimately goes into this risk assessment. And at the other end, considering all of that, considering a separate risk assessment, the static risk assessment, considering the compass risk assessment, all of those together yielded a conclusion that he was a low recidivism risk, even including that troubling fact, Your Honor. I don't disagree that might be troubling, but looking at it with everything else as part of that evaluation, he still scored a level 2 out of 5, which means he is a lower risk than the average, not the average person, not the average prisoner, the average person who has committed a sex offense. So that's who they're measured against in these risk assessments. So that was part of the record, and I think put in the proper context, that in and of itself may not be a substantial and compelling reason. But even if a court found that, it would still have to look at the entire record. And I wanted to emphasize that because I believe that's where the Court of Appeals went astray a bit. They found a substantial and compelling reason, and from reading the opinion, it seems that they believed they were bound to therefore reverse. That is not the equation here. If there's a substantial and compelling reason, you still move on to look at all of the facts and circumstances as the statutory charge in 233(1)A.
Would you say that it's a high bar for the reviewing court to reverse?
I think it's an extremely high bar, and that's for good reason, Your Honor, because the parole board is the expert here. It makes thousands of parole decisions every year. It's equipped by the legislature with the parole guidelines, with these risk assessments I've talked about. This is the expert agency that does this every day, that weighs these matters, and has a specific goal, which is to make sure there are reasonable assurances that the prisoner will not be a menace to society. And so there's a lot of technical knowledge, there is a lot of experience here, and courts reviewing it, I think, understandably, are going to be drawn to certain facts when, there's a lot of prisoners who have done terrible things. And that doesn't mean that they're never eligible for parole again, because ultimately the consideration of punishment and retribution, like I mentioned, that's for the sentencing court to detail how long the person's minimum and maximum sentence are. And that crime is still relevant for the parole board's consideration, but it is part of a different record and towards a different goal, which is ensuring public safety.
Questions? Okay. Thank you.
Good afternoon, Your Honors. May it please the court. My name is Todd Schmitz, appearing on behalf of the Macomb County Prosecutor's Office, which is the plaintiff appellee in this matter, and joining me at counsel table is Assistant Prosecuting Attorney Emil Saman. At the time of Mr. McBrayer's conviction and sentencing on 2 counts of criminal sexual conduct in the first degree for raping his stepdaughter in 1994, she was a scared and injured 14-year-old little girl. She's not a scared little girl anymore. She's a brave, courageous woman who asked me to share with you that she's joining us in the courtroom today, as she has every step of the appeal process, even though it has meant disclosure of intimate medical details through the cases, even though it has meant reliving the horror which Mr. McBrayer has inflicted on her, and from which she has told the parole board that she suffers to this day, both mentally and physically. We're asking this court to reverse the November 4th, 2020 decision of the Michigan Parole Board to grant parole to Mr. McBrayer because there's substantial and compelling reasons that the parole board abused their discretion. In this case, Your Honor, there's a hole in the law, and there's a gap in parole appeal law. And that gap is there is no standard for how close in proximity can the parole board force a woman to live near a paroled prisoner who raped her as a child when a suitable parole plan could be implemented that does not put them in close proximity. The cases that have discussed this before have focused on two main areas where discretion has been abused. One is the nature of the offense for which the prisoner has been incarcerated, and second is the readiness for parole based on a suitable and realistic parole plan. And the suitable and realistic parole plan is important here because the factor includes staying away from his victim. The parole guideline scores mentioned do not take proximity to the victim in account. There is no proximity to victim score. An example from Justice Clement, when you were asking what would be an example of an abuse of discretion, one example would be if the parole board decided to parole him near a daycare center. Clearly that would be not good. But there are specific examples in this case as you grapple what's the standard, how close is too close. In this case, in McBrayer 1, he was going to be paroled to Louisiana. That was far enough away, but unfortunately that plan failed to materialize. In McBrayer 3, he was paroled, but it was within 4 miles of the victim. That was too close. In one of the prior cases, she alleged she saw him at a traffic light, his desire to stay away from the victim. 4 miles is too close. Now in this case, now we're at 16 miles. And the standard imposed, the distance imposed in this case, this time by the parole board, is arbitrary. They have a rule that says he cannot come into Macomb County. But he's only 16 miles away from the victim. He could have been further away within Macomb County. The victim and Mr. McBrayer could be further away at either ends of Macomb County than they can under the proposed placement that's only 16 miles. Now, of course, we have to weigh factors, we have to look at support systems, and one of the things to consider is work placement and other support systems, not just proximity. But and it would be different when the court balances if, for example, let's say Mr. McBrayer came up for the cure for cancer, the only place he can work in his lab is right next door to the victim. Well, then the court would do a different balance. But in this case, he didn't come up with a cure for cancer. He does lawn care. And there's nothing unique about lawn care that requires him to be relatively near the victim.
Help us determine what the appropriate standard is here, right? So there's no dispute, it was a high probability guideline score. So there has to be substantial and compelling reasons apart from that scoring, correct?
Correct.
And who has the deference, who has the discretion here? Is it the parole board? Right, the parole board, are they the ones that can look and make a determination of whether these substantial and compelling reasons justify not granting parole? Or is it reviewing courts? And if you're I assume you're gonna tell me the reviewing courts, what's the basis for that? Where does that authority come from?
It's both, Your Honor. Both would do that. And in this case, it has risen to the level of the courts because the parole board, in its exercise of discretion, failed to do so. The standard rises to
Failed to do what?
Well, as in the Killebrew and Babcock standard, as to whether it irresistibly or keenly grabs one's attention and is of value to the case. In this case, what irresistibly or keenly grabs our attention is that the parole board is again proposing placing him relatively near the victim 16 miles away when Michigan has over 56,000 square miles. That irresistibly grabs our attention as to what is the overriding reason why he can't be placed further away and why he needs to place there.
So what would be an appropriate distance?
In this case,
That wouldn't reach the level of a substantial and compelling?
for example, in this case, just as an example, and the court will have to weigh everything different depending on work requirements and family requirements and other things if there's a unique reason to be close. But as an example, a 100-mile distance would be a reasonable standard until the legislature steps forward to fill the current gap. And remember, we're only talking for a narrow application of the rule is our request because we're talking about the old rule, the pre-2018 definition of substantial and compelling evidence. The legislature changed it in 2018. They could have applied it to cases like Mr. McBrayer's, but they did not because it does not apply to offenses that occurred before that date. There's other things that keenly and irresistibly grab our attention, Your Honors. As the justices pointed out, the unique nature of the child rape crime, the damage to the victim, the 2018 Qualified Mental Health Report, where he reports over 2 decades of continued masturbation and fantasization involving the victim and children like her. Nobody has argued that he is fantasizing about the victim over 20 years because he wants to stay away from them. We want him to succeed when he is eventually paroled. And when that date eventually comes, we do not want him to be relatively near the victim. We want his chance of staying away from the victim to help him succeed and do that.
It's my understanding that the defendant is set to be released in 2 years.
Yes, Your Honor.
Is that the max?
Yes.
So, I mean, doesn't it make sense that he would be on parole for a period of time for there to be an opportunity to monitor, his choices and behavior?
It may make sense that, and when you look at one of the amicus briefs especially, that's expressly discussed, but what is not addressed, it does not make sense that if he is going to be paroled, that it must be relatively near the person he raped as a child when there is no good reason for that.
If he is denied parole and is released in 2 years, is there a restriction on where he lives at that 2-year period?
No,
Could he live next door to the victim?
No, Your Honor, there wouldn't be. So once he's released or once he's discharged from parole, either way, he's a free person. It would be well within your authority to remand this to the parole board for an explanation of the suitable and realistic parole plan for, is there a place that he can be paroled that is not relatively near the victim, or if he must be, then why?
Can I ask, the point you're making about the parole board's plan and the location between Oakland County and Macomb County, and you're saying that in this case that's a substantial and compelling reason, would it be under the current statute?
Yes.
It would
Yes.
remain,
I'm sorry.
it would remain one?
The current statute for substantial and compelling reasons
Right.
is more narrow. So under that definition, the legislature specifically said, from this point forward, 2018, here's the only things that are substantial and compelling. But that does not take effect for our case. Our case is pre-2018, so there's a wider range of substantial and compelling that applies to the pre-2018 cases.
Okay.
Would you agree with me that the lower courts seem to, at least the Court of Appeals, seem to come to the conclusion that if they could find substantial and compelling reasons to depart from the parole guidelines, that they could make such a ruling, and that would be all that would be required for them under law?
I would agree with you that the courts did find substantial and compelling reasons, but that's not all that was required. It is also required to show that it is outside the bounds of other reasonable consideration. And in this case, our position is that paroling a person relatively near his rape victim is outside the bounds of a reasonable outcome when the state has shown there is absolutely no burden whatsoever not to do that.
All right, so the second prong there, I'd say you'd have to find substantial and compelling, and I question your opposing counsel on the second prong. Considering all the facts and circumstances, was the board's decision not to depart from the guidelines reasonable and principled?
No, it was not.
Is that standard acceptable under the law? Does that accurately reflect and give deference to the parole board?
Yes, it does, and that's why parole appeals are so rare.
Okay, so your position, it's not reasonable and it's not principled for one reason, and that's because it permitted the parolee to be in the same county as the victim.
The main reason is, in this case, it's not the same county because there is a specific parole limitation that he cannot come,
Okay,
but
no,
relatively
within, all
near.
right, I got it, but close
Relatively
enough to the, you would rather, instead of having the county geographic description, you'd rather it be a radius of miles. And you're
Yes, not-
suggesting 100, maybe 50, whatever it is, they didn't do that. And the failure to do it and to allow it in the neighboring county, which could be very close to the victim, is not reasonable and not principled.
That's exactly right, Your Honor. The language the lower courts have used is not relatively near.
Do you see a difference between what I've just described as are there substantial and compelling reasons to deviate? And if there are, was the decision not to deviate reasonable and principled? Do you view that as different from what your opposing counsel is saying, where they would come to the conclusion that it must be affirmed unless it's outside, the failure to do so is, I can't even remember how they articulate it, but do you see a difference between what we just discussed?
The difference in our positions is that they have advocated a much more narrow role for the statutory obligations of the court to review the parole board's activity. We do not advocate such a narrow role for the court.
And in your view, the Court of Appeals did in fact apply this two-pronged standard that I've articulated?
Yes, Your Honor. And they've identified several things. The highlight of what keenly and irresistibly grabs our attention was, of course, the close proximity. It also is interesting that Mr. McBrayer says he does not want to be near his victim. His victim says she does not want to be near him, and yet the parole board keeps doing the same thing over and over again, expecting a different result. But every court that has previously looked at this has considered essentially similar things, but the courts have provided consistent results, and we're just asking for that again. In closing, Your Honors, I would just ask you to please reverse the parole board decision to grant parole, because in this particular case, there are substantial and compelling evidence of a clear violation of the standards. And it's time you can have some input and give some guidance as to what is the appropriate standard for how close can the state force a woman to live next to the man who raped her when the suitable and realistic parole plan does not require such close placement. Thank you.
Thank you. Thank you both. The case will be submitted.